Hello, my name is Shantavia Johnson. I teach intellectual property law courses at Drake University Law School in Des Moines, Iowa, in the United States. And the lecture that I'll be giving to you is on international trademark law and immoral or offensive trademarks. And so we start with this premise that there are some words that are just so bad that we don't want to allow individuals and businesses to own them. So if you take a minute and think of some of the worst words you can possibly think of, some of the most offensive words, some of the most immoral words, some of the most degrading words, the question really for countries around the world is whether or not we should allow people and businesses to use these words and phrases and symbols in their businesses, in their companies, to sell products to consumers. And obviously, this can raise a couple of different questions. Most of us try not to be offensive to other people. Most of us try not to say things that would harm people. Most people try to conform to social standards and do what is appropriate. However, there's no absolute barometer for appropriate behavior and speech. So there's no real way to know whether or not the use of a particular word is appropriate under every set of circumstances. Some of us are more sensitive to certain words or symbols than others. So even though I might be offended by a term, it might have little to no effect on the vast majority of other people. Trademark offices around the world really have been confronted with these types of questions. And so, what I'd like to do is introduce some of these issues to you as you think about how to go about considering the answers to these questions. So, as I mentioned, there are some words and symbols that have little to no effect on one person but upset others. And trademark offices have to figure out what to do with these words that upset and offend some of their citizens. Trademark offices around the world in dealing with these words that offend some of their citizens have created prohibitions on the registration of what we typically call immoral or offensive trademarks. So, with this lecture, what I'd like to do is introduce you to some of the basic principles, some of the basic legal standards dealing with these questions of immoral or offensive trademarks. So, I will essentially cover four different things. I'll go through some trademark law background. I will provide at least the basis of international law in this regard. I will talk a little bit about four different domestic trademark law provisions from four different areas of the world that deal with this question of how to either completely disallow registration for these immoral trademarks or other ways in which these countries might deal with immoral or scandalous trademarks. And then I'll give some examples from two countries, yours and mine, from the United States and from China. There will be some other examples that I won't discuss that I've provided in some of the materials that I've given to your professor. You should feel free to look through those materials if you're curious about this topic to see what other types of trademarks around the world have been found to be immoral or unregisterable for being offensive in some way. So I'll also actually talk a little bit about whether or not there's any international consensus over what exactly makes a mark so bad or so offensive that it should not be registered. So let's start first with the background, the basic requirements for trademark protection around the world. Of course, there's no one uniform standard, though we can essentially whittle down the trademark requirements around the world into two primary considerations or two primary conditions. The first requirement relates to the core function of trademarks, namely to identify the commercial source of goods or services and distinguish them from the goods or services of competitors. This means that a trademark must be distinctive. A trademark must be capable of distinguishing the goods or services of one from those of another. The second condition for granting trademark protection relates to the possible harmful effects of a trademark if its use is likely to either be misleading or violate some type of public order or morality. So we have really these two standards working together. Number one, the trademark must be distinctive. And as the argument goes, some of the most offensive or scandalous or immoral trademarks are probably pretty good at this, at being distinctive. But that might run afoul of the second requirement. We don't want to mislead the public, number one, and we don't want to violate some type of public order or public policy or morality. And this lecture really focuses on this latter prong, this question of violating public order and morality. And so we really have to ask ourselves a couple of different questions in figuring out whether or not the use of a particular word or symbol or phrase or device violates public order or morality. Is there a need even to protect the public from this type of thing, from immoral or offensive trademarks? And that's really one of the first questions. Do we need to protect the public in some way from the use of these words by business people, industry, individuals who are selling products and services? And then number two, how do we actually determine morality? How do we define morality? And these are very difficult questions to answer. What is necessary, number one, do we have to have these complete prohibitions? And number two, to the extent that there are prohibitions, who gets to decide what is moral and what is immoral? And so, in that vein, if we have these two broad questions, the next step really is to figure out what the law says in this realm. And so we can start really with international law. And in terms of international law, the primary law outlining when a mark that is immoral or offensive in some way can be denied registration stems from a particular convention that's administered by the World Intellectual Property Organization. I'm sure you're familiar with it. By now, it's called the Paris Convention for the Protection of Industrial Property, which of course is administered by WIPO, by the World Intellectual Property Organization. It is the first international treaty for the protection of intellectual property rights. So the Paris Convention was signed in Paris in 1883. It was one of the first intellectual property treaties, and it established a union for the protection of industrial property. And the article that I have reproduced for you on the slide here outlines the prohibition on immoral trademarks. And essentially, what the Paris Convention states is that trademarks can't be denied registration or invalidated except under very specific circumstances. And subsection 3 is really what's most relevant for this lecture, which outlines that trademarks may be denied registration or invalidated when they are contrary to morality or public order, and in particular are of such nature as to deceive the public. And the Paris Convention goes on to say that it is understood that a mark may not be considered contrary to public order for the sole reason that it does not conform to a provision of the legislation on marks, except if such provision itself relates to public order. So we start with this premise that marks that are contrary to morality or public order are not registrable under the Paris Convention. Then, after the Paris Convention, we have two other agreements essentially supporting what comes out of the Paris Convention. The first is the Madrid Agreement concerning the international registration of marks. Article 5, subsection 1, essentially directs us back to the Paris Convention. It says that marks can be refused registration under the Paris Convention. And then also we have the TRIPS, which I know you're familiar with as well, which is administered by the World Trade Organization. And the TRIPS agreement from 1994 does not directly refer to public order or morality as a ground for refusing trademarks in its principles, but it's also helpful to consider for a couple of reasons. Because the first thing TRIPS does is say, here are the types of trademarks that are registrable. Any sign or combination of signs capable of distinguishing the goods or services of one undertaking from those of another undertaking should be capable of constituting a trademark. But there are limitations on this, because this is pretty broad language, of course. There are limitations, though, to these marks that may be capable of distinguishing goods and services of one from those of another. And that comes from Section 2 of the TRIPS Agreement, from Article 15, subsection 1, or Section 2. And Section 2 says essentially that member states can deny registration to trademarks on specific grounds, specifically those outlined in the Paris Convention. So the TRIPS agreement directs us back to the Paris Convention, which provides for trademarks to be declared invalid based on public order or morality. So the Paris Convention, the Madrid system, and TRIPS, all three of those work together to disallow registration of certain trademarks if they are immoral or offensive in some way. Essentially, of course, saying that if they are contrary to public policy or public order or morality. So we start with this international premise that trademarks that are contrary to public order or morality are not registrable. But then, of course, we have individual countries interpreting this language in a way that is beneficial in those individual countries. So, what I'd like to do next is talk a little about various types of domestic law from around the world and how we see, as a practical matter, this type of thing playing out in different countries. So, the first thing I'd like to do is just provide a little bit of a comparative analysis of the law from four different parts of the world: the United States, China, the European Union, and Australia, just to give you some idea of the different ways in which countries might deal with these trademarks that are contrary to public order or morality. So we will talk about at least a little bit the law from these four different areas, because domestic lawmakers essentially have a fairly wide latitude in crafting and or applying morality-based exceptions to trademark registrability and validity under international law, which again comes primarily from the Paris Convention with those other supplemental agreements that I mentioned earlier. So the following is just a short list of example law from around the world. And again, I'll talk about the law from the United States, China, the European Union, and Australia. So I'll start with what I'm most familiar with, which is the United States. And trademark law in the United States comes from the Lanham Act, which is Title 15 of the United States Code. And essentially, the Lanham Act in Section 2A outlines the standard for prohibiting registration of immoral trademarks. The statute essentially prohibits the registration of immoral, deceptive, or scandalous matter, among other things. And so we start with this premise that if something is immoral, deceptive, or scandalous, it cannot be registered in the United States in the trademark registry. The United States Patent and Trademark Office has a manual of examining procedure, which says essentially that there's an absolute bar to the registration of immoral or scandalous matter. And even though we use these different words, immoral or scandalous, they have somewhat different connotations as dictionary definitions go. U.S. case law really has included immoral matter in the same category as it does scandalous matter. So we treat them roughly the same. And there are various categories, really subcategories of immoral or scandalous matter that could preclude registrability of a word or symbol that a person wants to use as a trademark. And so essentially, if something is immoral or scandalous in one of these categories, it will not be registered. Religion, ethnicity, sexual references, drug references, violence, profanity, and vulgarity. There can be a tension, though, between the First Amendment and trademark law in the United States, because by and large, the United States really is a nation that prides itself on freedom of speech. So if you're criticizing the government or using distasteful language or propagating unpopular or distasteful ideas, that's almost always permitted with, of course, certain exceptions. And so to disallow a person to have a registration for certain words or phrases kind of sounds like a prohibition or sounds like it might run afoul of the First Amendment freedom of speech. But what American courts have said is that refusing to register a proposed immoral or scandalous trademark does not abridge the First Amendment because no conduct really is prescribed and no tangible form of expression is suppressed. Because practically speaking, even if the mark is not registrable in the United States, a refusal to register does not preclude an applicant from selling merchandise or rendering services under a proposed mark. They can use the mark, they can use it aloud in their commercial transactions. It just can't be registered. It simply means that the applicant is not able to call upon the resources of the federal government in order to enforce that trademark. In the United States, what constitutes immoral or scandalous? This really has evolved over time, and in a couple of minutes, I'll show you a few examples from the United States and also from China, just in terms of what types of things are considered immoral or scandalous. What the United States courts have recognized and acknowledged is that we have to be cognizant and mindful of the changing social attitudes and sensitivities of individuals in the United States. Because some things might be immoral one day or scandalous one day, and not so immoral or scandalous the next day. I'm sure all of you are quite familiar with the trademark law of the People's Republic of China, but I'll just mention a couple of things here briefly regarding China's standards for prohibiting these trademarks that are contrary to public order or morality. So, Article 10 of the Trademark Law of the People's Republic of China outlines the standard for prohibiting these trademarks. The statute says that the types of words or devices that cannot be used as trademarks include those detrimental to socialist morals or customs or having other unhealthy influences. The trademark examination guidelines of the CTMO explain what is understood by the legal terms socialist morals and customs and by the terms unhealthy influences. So when we use the term socialist morals and customs, those are the common rules, standards, customs, and practices of the Chinese nation prevalent in a certain period of time. Signs that have a negative influence on China's politics, economy, culture, religion, nation, or otherwise usually fall within this realm. When we see that term unhealthy, is my understanding that social interests or moral standards are regarded as unhealthy. The wording of these definitions reveals that they are not set in stone but can change in the course of time. And there are various categories here under Article 10 of the Trademark Law of the People's Republic of China. Those categories, which I've reproduced for you in the slide, include signs detrimental to socialist morals and China's politics, racist signs, signs detrimental to religion, signs conflicting with governmental authorities or official national currencies, misleading signs, and signs having other unhealthy influences. The European Union, on the other hand, essentially bifurcates their prohibition on the registration of these types of trademarks. So in the European Union, they use something called the Manual Concerning Proceedings before the Office for Harmonization in the International Market, OHIM. OHIM The OHIM is responsible for managing the trademark registration process for all of the 28 member states of the European Union. So within the OHIM, Part B, Section 4, 1.2.1 is entitled Public Policy and Morality. And it essentially states that certain trademarks are excluded from registration. And those that are excluded from registration are those that are contrary to public policy or to acceptable principles of morality. So their language follows pretty closely with the international standards. So the rationale here is to preclude trademarks that would be perceived by the relevant public as going directly against the basic moral norms of society. So the OHIM considers that public policy and acceptable principles of morality are two distinct and different concepts, though sometimes they overlap. So the public policy objection, on the one hand, derives from an objective criteria. It's not based on the perception of specific relevant members of the public, unlike the principles of morality, which more or less are. It's based on a more subjective criteria. So we have these two different concepts, public policy and principles of morality, that allow for the consideration of either objective criteria or subjective criteria. And the European Union excludes registration of racist, discriminatory words or phrases, blasphemous words or phrases. So in terms of the substantive types of prohibitions you'll see in the European Union, they're pretty similar to what we've seen really in other countries, even though the terminology and language is a bit different. The European Union, like the United States and other countries, acknowledges that it's normally necessary to consider the goods and services for which registration of the mark is sought, because the relevant public may be different for different goods and services, and so you might have disparate thresholds with regard to what is considered offensive. Words considered to be bad language is likely to be unacceptable, though it really is kind of an interesting assessment in terms of substantively what is allowed and what is not allowed. And then finally, just for comparison purposes, we have Australia, which prohibits the registration of scandalous matter through the Australian Trademarks Act of 1995. So When we say scandalous matter in Australia, what do we actually mean? This is a relatively high standard. Scandalous means disgraceful to reputation, shameful or shocking, or defamatory or libelous. And this threshold again for rejecting an Australian trademark application under this standard is relatively high. The Australian manual states that the scandalous element has to be something that is obvious and upfront in the mark. A mere suggestion that someone might find it offensive is not sufficient. So as we can see, even though various countries around the world use different language and terminology, we're all getting at the same type of problem, which is we want to protect the public in some way from these words that are so offensive or so immoral that public policy and morality say these types of things should not be privatized. So what are some examples of of these things? So I won't give many examples. As I mentioned earlier, I provided some supplemental material where you can see lots of different examples and read about various examples. I will talk about a few from the United States and China. One of the first from the United States was this term, cocaine, as applied to soft drinks and energy drinks. Cocaine, of course, in the United States being an illegal and illicit drug. And the Trademark Office did not allow this trademark to register, in part because the Trademark Office was concerned that children and teens could get their hands on this product. It was being advertised in a way that suggested that if you drank this particular product, it would have an illegal drug like effect. And the Trademark Office said this is just scandalous. This is not the type of thing we want to register on the trademark registry. Another example was this wife beater for t shirts, where the applicant's trademark was this, as we see on the screen, but there was also separately a logo where there was a man spanking a woman. The applicant offered free t shirts to men who had been convicted of beating their wives. And the Trademark Office again said here, this is going to be refused. We will not allow this type of registration to issue. The United States Trademark Office, however, has been inconsistent in some instances in terms of what is considered immoral. So, one example is this, which is a frog holding up what seems to be a middle finger. The middle finger, of course, in the United States, being a gesture that is considered vulgar in many instances. And the Trademark Office allowed this particular trademark to register after some back and forth between the examining attorney and the Trademark Trial and Appeal Board. Essentially, they said this is not scandalous. This mark could be registered because even though the middle finger being raised might be offensive, here it's a frog and it's not directed to any particular group of person who would think this was scandalous or immoral. And then I have a couple of examples from China that I'm not going to try to pronounce, but these two trademarks were found to be signs detrimental to socialist morals. This first trademark, my understanding, can be translated as kill them. It was refused trademark protection because it was regarded as detrimental to socialist morals. This mark was rejected for the same reason, which apparently stands for street overlord. So you can see just kind of the types of trademarks that have been disallowed around the world for being immoral or offensive in some way. So, in conclusion, I'd just like to say a couple of things about this particular topic. Number one, there are decisions from around the world that have a lot in common. Statutes from around the world have a lot in common, even though the text of each jurisdiction's law is different. Almost every jurisdiction recognizes that social attitudes are changing and that trademark offices have to be cognizant of this social and cultural shift when evaluating trademarks. One of the problems with this, though, is that when you're assessing a trademark for its level of offensiveness or immorality, this is undoubtedly going to be a subjective question based largely on subconscious notions and values held by a person reviewing the application. And this can lead to inconsistent results. Attorneys in the United States complain quite frequently about the wild inconsistencies in the U.S. Trademark Office in this regard, specifically with respect to immoral and scandalous trademarks. And again, as we mentioned, how to define morality really is a difficult question that has to take into consideration an individual's personal sensitivities, which can be difficult if we're attempting to make, in many instances, an objective assessment of the immoral nature of a immoral or moral nature of a particular trademark. And then finally, the question that I mentioned earlier in the lecture, is this necessary? Do we need to protect the public and maintain public order in this realm of trademark law? Uh, that is the conclusion of the lecture. Thank you for your time. If you have questions, please feel free to email me. I appreciate your time. Thank you. Have a good afternoon.